I'm starting the live stream again. The issue remaining is the petition for an emergency stay and leave to grant an interlocutory appeal. And of course, that is governed by 808.03 sub 2, a permissive appeal. And that section says, in a judgment or order not appealable as a matter of right under sub 1 may be appealed to the Court of Appeals in advance of a final judgment or order upon leave granted by the court if it determines that an appeal will A, materially advance the termination of the litigation or clarify further proceedings in the litigation, B, protect the petitioner from substantial or irreparable injury, or C, clarify an issue of general importance in the administration of justice. I don't think sub C applies here. We are talking pretty well-established areas of criminal law. 2A is the determination I talked about a little bit earlier, whether granting the leave would materially advance the proceedings. There are a couple of issues that have been identified that the parties wish to appeal. The first is the motion to reconsider the rejection of the plea agreement, and that is a discretionary decision well within this court's domain. Okay, the live stream was muted, my apologies. Now, the defense argues today that the fact that the court believed that a plea agreement on its face depended upon the district attorney's motion to dismiss and read in charges was contrary to the public's interest, for a range of reasons that were stated on the record last week, one of which was the court's ability to dispose of the case in a manner commiserate with the seriousness of the criminal charges, the background and character of the defendant. But the court also cited the interests of the victim, which have been pretty much ignored in the motions to reconsider filed today, the various factors set forth in State Ex Rel. Kalal versus Circuit Court of Dane County, 2004, Wisconsin 58, paragraph 32, and the reasons stated by the DA and by the defense. I agree that I ruled before hearing from the defense, because I was told that the agreement reached was dependent on the state moving to dismiss and read in 6 of the 8 charges. I did not find these reasons by the state compelling. And before confirming my ruling and before adjourning on Thursday, I did consider the very extensive arguments that were made by the defense. I also considered today the briefing and extensive arguments made this morning in favor of the motion, or the rule, before ruling on the motion to reconsider. This order of proceedings does not mean that this court is biased. It means that the state could not and did not make the required showing. And as I stated earlier, there are 2 ends of the spectrum in terms of the court's concerns over my ability to dispose of the case in a manner commiserate with the factors to be considered. And neither end of the spectrum was satisfied in the comments made by the parties in support of their agreement, which is related to the brief discussion and reference made to the amount of pre-sentence credit, which is of no real concern at this stage. It's of no real concern at all, except as a symptom of the posture the state has taken for the last 6 years in this case. And with that backdrop, I expect some compelling reason for the plea agreement, which has such a significant departure and was given none. The second factor under the interlocutory appeals section is whether the petitioner is protected from substantial or irreparable injury. And I commented on that earlier today too. The defendant's rights are preserved either way. If he were ultimately to be convicted of something, he has the right to appeal. If he is not convicted of anything, then there's no issue. I'm satisfied that granting an interlocutory appeal would in no way materially advance these proceedings. Now, there's also the motion to recuse. And a new judge, there's no guarantee that any judge would rule any differently on any of the motions, of course. And there is a strong presumption that I'm not biased as the presiding judge. We've talked about that. Again, that's State versus Herman, 2015, Wisconsin 84, paragraph 3. These would have to show that there is sufficient information, aside from the one clause that has been pulled out from the comments on Thursday, to show that I have prejudged this case, which I do not think is true, which I also believe supports the denial of the motion for an interlocutory appeal. I do not believe there is a strong likelihood of prevailing on those motions for the reasons that I have already stated. So I'm not going to grant the leave, I'm not going to grant the stay. I expect we will pick a jury starting at 8:30 tomorrow morning.
Just to clarify, our motion's not asking you for leave to appeal. Only the Court of Appeals can give leave to appeal. We were asking for an adjournment to allow the Court of Appeals to make that decision.
They are welcome to make that decision. I'm denying the motion for the adjournment.
Judge, can I just clarify with just one thing for the record?
Of course.
Okay. I believe the court said that the state did not take into consideration victim concerns?
No, I do not say that the state did not take into consideration victim concerns, and if I did, that's not what I meant. The motion to reconsider, I think, discussed the, did not reference the victim's concerns that were raised on Thursday.
I just want to, because of victim rights, if I can make a record.
Please do.
Okay, thank you. There are multiple victims in this case, and there's reasons we wanted the submission sealed, which the court, thank you, had granted. There are victim concerns throughout this, and I believe the written submission documents the concern specifically to one of the victims regarding trauma. We did, after last Thursday, over the weekend, we were able to have a much more in-depth conversation with one of the victims. And we took time over a very long period of time to answer any questions, things like that. And that's also detailed in our motion to reconsider. So there is, the state did take into account all concerns with all victims, and that was the driving force for this submission and the driving force for the reconsideration. I just want that clear.
Can you clarify for me, and I keep referring to a victim as the adult, who I think speaks on behalf of the children. Is that person in a different position today as to whether she wishes to proceed with the plea agreement versus the trial?
I think it's difficult to say. This is an extremely stressful situation for her, and there is a lot of things for that person to consider. It is a lot. So we did, we had the long conversation over the weekend. We tried to answer questions as best we could. Even when the court allowed us to have a break to have more time with her, we were able to discuss with her not only the potential of adjourning the trial, but other questions. I can't speak as far as what her opinion is on the plea agreement, and I think it's a lot right now for her to process. So I don't know if I can say whether her position has changed, whether it's neutral, or whether it's the same as Thursday. The only position that I know I can speak to is that she was fine with the adjournment to try and have some finality, to try and reduce the chance of the other victims having to testify more than once. So that is the only one I'm comfortable stating, that she is fine with an adjournment. I don't feel that I can speak on the other issues.
And I want to be clear that the wishes of the victim are one of the factors to consider. It's one I take very, very seriously. I'm directed to by statute, by Wisconsin Constitution, and also by the cases that we've discussed at some length. It is but one of the considerations, just as it's just but one of the considerations that enters into any kind of plea agreement. But it is an important one, and I appreciate that this is very difficult for everybody. I don't believe, though, that delaying it any further is going to make it any easier. I think this matter has been so delayed that dragging it out further may only make the trauma worse. Of course, I do not have any conversations with anybody involved directly or personally. I have not spoken with any of the victims, of course. But I really am concerned about delaying this already very old case any longer.
Judge, it's difficult to answer that question in open court.
Particularly, if I may, recognizing that we would not be delaying the case at all had we been able to enter a plea either Thursday or today.
Do we want to have a sidebar conversation then?
If the court's willing. Just for confidentiality reasons, is there another room we could utilize without microphones that are on?
Yes, we use the jury room.